When a crime is committed, it often results in both criminal and civil liability. Criminal liability focuses on punishing the offender and deterring future crimes. Civil liability, on the other hand, aims to compensate the victim for the harm suffered. This essay delves into the concept of civil actions arising from criminal cases, particularly examining Rule 111 of the Rules of Court, which governs this interplay in many jurisdictions. Imagine a scenario where a person is physically assaulted. The state may file criminal charges against the assailant for assault and battery. Simultaneously, the victim can file a civil lawsuit against the assailant to seek compensation for medical expenses, pain, and suffering. This example highlights the parallel yet distinct nature of criminal and civil actions. This essay explores the legal framework governing the institution of civil actions in criminal cases. It examines the general rule, exceptions, and types of civil actions typically involved. Further, it discusses the dual concept of civil liability, encompassing both crime-based and quasi-delict liabilities. Understanding the interplay between civil and criminal actions is crucial for both victims seeking redress and individuals facing potential liability. This essay provides a concise yet comprehensive analysis of these concepts, aiding in navigating the complexities of the legal system. Rule 111 of the Rules of Court establishes the general principle that the filing of a criminal action automatically institutes a civil action arising from the same act or omission. This means that a separate civil suit need not be filed in most cases, as the civil aspect is deemed included within the criminal case. This rule is grounded in the principle of judicial economy, aiming to avoid multiplicity of suits and conflicting judgments. By integrating the civil aspect into the criminal case, the court can efficiently resolve all issues stemming from the same event. The legal basis for this rule can be found in several articles of law. Article 100 of the Revised Penal Code states that every person criminally liable for a felony is also civilly liable. Articles 2176 and 1157 of the Civil Code further reinforce this principle by establishing the obligation to compensate for damages arising from acts and omissions that cause harm to others. This general rule simplifies the legal process for victims by automatically initiating the civil aspect of their claim. It ensures that the court considers both the criminal and civil implications of the act, providing a comprehensive resolution to the case. While the general rule promotes efficiency, certain exceptions exist where a separate civil action is permissible. These exceptions aim to balance the interests of both the victim and the accused, ensuring fairness and due process. One exception is when the offended party reserves the right to institute the civil action separately. This reservation must be made before the prosecution presents its evidence in the criminal case. This provision allows the victim to pursue the civil action independently, potentially in a different court or at a later time. Another exception arises when the civil action is filed before the criminal case. In such instances, the civil action is suspended upon the filing of the criminal case. This suspension aims to prevent conflicting decisions and prioritize the resolution of the criminal charges. Additionally, certain civil actions are not deemed instituted with the criminal action. These include actions based on contracts, quasi-contracts, or other causes of action not arising from the criminal act. For instance, a breach of contract claim unrelated to the criminal offense would require a separate civil suit. Understanding these exceptions is crucial for victims seeking to pursue their civil remedies. It ensures that they are aware of their options and can choose the most appropriate course of action based on their specific circumstances. Section 4. Types of civil actions deemed instituted. The civil action deemed instituted with the criminal action is limited to the recovery of civil liability arising from the offense charged. This encompasses restitution, reparation, and indemnification for damages caused by the crime. Restitution involves restoring the stolen or lost property to the rightful owner. Reparation refers to the payment for the value of the damage caused, while indemnification covers consequential damages such as lost earnings or medical expenses. For example, if a person is convicted of theft, the court can order the return of the stolen item, which is restitution, and payment for any damage it incurred, which is reparation. Additionally, the victim can seek indemnification for lost wages if they were unable to work due to the theft. It is important to note that the civil action deemed instituted is limited to the specific offence charged in the criminal case. If the victim wishes to seek damages for other causes of action, such as defamation or emotional distress, a separate civil suit must be filed. Understanding the scope of the civil action deemed instituted is crucial for both victims and defendants. It defines the boundaries of the civil claim within the criminal case, ensuring that all parties are aware of the potential outcomes. Further, it discusses the dual concept of civil liability, encompassing both crime-based and quasi-delict liabilities. Understanding the interplay between civil and criminal actions is crucial for both victims seeking redress and individuals facing potential liability. Conclusion, key takeaways and implication.